Mr. Booker, if you'll come forward, please. Go ahead and have a seat right here. Lecture. Oh, I'm sorry, I thought Mr. Booker had already seen his fee papers, he does not, so can you give these to Mr. Booker and do those? I'm sorry, Mr. Booker. Give you this paperwork, go ahead and go to the back, let me know here, just review it. Sorry, I thought you had already signed it. Mr. Manning, are you ready on anyone?
Judge, I have Mr. Palmer set on a motion to dismiss. That was filed, served in the DA's office.
Make sure Mr. Booker has the pen. I'm sorry, Mr. Manning, what did you say?
That is a motion to dismiss, file. Like I said, served on the DA's office, June 14th, under session, Article 3201.
All right, Mr. Copper, state received a copy of the writ.
Yes, Your Honor.
Is there any objection to Mr. Manning's motion to dismiss?
No, you know, there's no objection to it, Judge. I don't think this court is jurisdictional. It's still a JP matter. It's filed to make a decision. No, you got no objections. This prosecution. This one. Judge, I have for my client that at any point in time with essential litigation, they would like to file a case, or can you get a case filed there with the right to do so? He understands that, however, he is requesting to sign release conditions bond. He lives in South Texas, so financial reporting and checking into the bonds from that is difficult on him as he tries to get his life sorted out and work and take care of his.
Sir, you said you believe that this report lacks jurisdiction over this case.
Well, I think in this particular point, Manning filed it in three, so. Although, I don't know if that's. I agree with the underlying complaints that because no cause of action has been filed, or document information has been filed, that it needs to be released from the line. And in addition to the current, whether that is just reported or may be better at this point. I don't know because it was filed. But for the writ filing, yes, I think it would be a change.
What way would Mr. Manning need to file this report to have jurisdiction?
I don't believe there is.
Mr. Manning, you agree or disagree?
Judge, obviously, the writ filing was a procedural issue. I chose that because there's no other way to file into a criminal case in Mazing County other than select what's entitled a pretrial writ of habeas corpus. As it is a pretrial issue and as it needs to be raised timely, I file it under that section as a writ back up. Then a procedural examination happens, whether or not it's more properly filed in district court or JP court. I did follow what instructions are in 32.1, which is the time deadline, 180 days after the arrest. And as he is being held on a felony matter for bail, and I thought that court case file jurisdictions like we file in the other pretrial issues.
And I certainly have no objection to the court granting it. I think,
But if I don't have jurisdiction, I don't have jurisdiction. Ex parte Seidel said the district court lacks jurisdiction over a case when an information or indictment has not yet been filed in that court. It's citing in that case that the information or indictment had not been filed when the trial judge dismissed the bail and prosecution against the defendant. The district court, however, had proper jurisdiction to act on the Speedy Trial Act because the defendant was held to bail for his appearance to answer any criminal accusation before the district court. Since generally a trial court does not have the power to dismiss a case unless the prosecutor so requests. The trial court does, however, have the power to dismiss a case without the state's consent under 3201, 28061. Which bars further prosecution for a discharge offense no longer applies, 3201. So it appears here that the motion to dismiss cites 3201. Does not base the motion is not based on dismissal for speedy trial because of lack of indictment or information. So it appears that this court would not have jurisdiction to grant a dismissal solely under 3201. However, if a writ was filed citing lack of speedy trial, then there's established case law, so I do have jurisdiction to grant that. So
I asked this, I most likely would file this in the JP court where it was issued. However, if we get the only able to file as written, I would ask my client to prepare remotely as he did drive all the way from South Texas.
and judge, it's civil action, his client doesn't have to appear at all.
but you're indicating you're gonna be doing that in trial, right?
Judge,
You said the JP board,
I will let's see which.
so it doesn't matter what I say. Because I'm on the JP board.
Oh, but
Well, that's speedy trial. Then that's going to.
So if you're gonna file it as a JP board, then you don't need to file it here.
Judge, as I said, I don't know jurisdiction where it's from. I'm being told it's not proper here, so I like to research that issue. I find that it's more proper.
Well, I think I just laid out when it would be proper here. Right, you filed a writ, you cited dismissal under 3201 for lack of speedy trial. There's an established case, ex parte Idaho, 39 Southwest 2nd 221. 39 Southwest 3rd, I'm sorry, Southwest 3rd 221.
and all I'm saying is that if for any reason he has to wind up doing it as a writ, the writ is a civil action. And his client doesn't have to appear.
Well, that's all.
But I think if you do it in the JP board, there would be no any request to appear via Zoom, obviously would be within my jurisdiction. So
I was specifically referencing comparing my Zoom to this file here.
So at this time, I don't believe that I have jurisdiction to either grant or deny. All right, do we have any other attorneys over there? Just one of you, yes, who are you ready? Connie. Mr. Cooper. All right, this is file number CR 2326, CR 2239, State versus John Cooper Junior for Docket called with one.
So yes, Your Honor, this works where I was recently on this case. I apologize for the confusion in the last setting. I was out of the office while the state was hiring me. So anyway, I received discovery. So obviously, it's time to keep it. I need sufficient time to see any appropriate control that.
Any objection, state?
No, Your Honor, may counsel approach?
You may. All right, court will reset Mr. Cooper for an additional docket call. Court will set, David Callen, Mr. Wine, as I said, August 8th, 10th, 22nd. 8th, 10th, that's the 22nd, 20. Morning will be terms here shortly. If it's in the afternoon, Mr. Wine. If it's in the afternoon, council.
No. So I would probably rather do it on the 10th.
Yes, so it's what seven. August 10th. August 10th. Well, I need for 1:30, it's gonna be sent on. Jail. Got it. I just knew that you had a conflict on certain things. Got it. Yeah, Mr. Cooper, come over here and have a seat in the jury box. Pretrial police officer will be made just.
And Judge, I believe I have an agreement with on Mr. Hicks' case, Gary Anderson. I filed that motion. I mean, raise my dollar.
All right, well, this is already 295, we do not have Mr. Anderson available in jail. Just go ahead and have him step up.
Can we get Mr. Anderson, please?
Stay right there.
Sir. We're getting Mr. Anderson for you, but we have one. I can hear you. Can you hear us?
Your Honor, can you hear us here at the jail? I would say that's a no.
All right, Mr. Abraham, can you hear me now?
We can hear you. Can you hear us?
Now I can hear you. Do you have Mr. Anderson, Jerry, or anything?
He's on his way in.
Okay.
We do have one reset if you want to go ahead and do it.
No, not yet. Not yet.
Mr. Anderson. Would you come up to the-
All right, good afternoon, Mr. Anderson. Mr. Weiner is present here in the courtroom. We've called your case. So the motion for continuance is agreed by the parties. You're requesting additional 60 days. It's a motion to revoke. Is the proposed plea agreement going to be time or extension on probation? Or
It's not a touch. He just needs to. Violations on.
Okay, my only concern was that he's probably been in jail at least 30 days before I didn't want to set him out for 90 days on the motion for vote. But I know ultimately what the end goal was.
Yes.
So the court will grant. On setting in, said 60 days, so that'd be the end of August. We're gonna do that August 22nd. All right, court will set Mr. Anderson for the court August 22nd. That would be at 1:30.
Your Honor, did you say for a plea?
Yes.
Around, result, my spread has to, barring that, maybe it's a page. Uh,
Very,
So
change the paperwork on the Booker's judgment. It says attorney, this is John Manning. We're gonna need to say, that's, we need to say pro se.
okay, yes, Your Honor.
It's not at all, but All right, we are back on the record regarding calls number CR 2326, CR 2339, state versus Johnny J. Cooper, Mr. Whitehill as the court's pretrial release supervision officer, and you conducted the analysis test on Mr. Cooper. That's correct. Yes. All right, I'm asking, make sure I. So you swear in the testimony you get to the court today in this matter, be the truth, the whole truth, nothing but the truth, so be done. Thank you. All right, Mr. Whitehill, can you tell me what the results of the test were? Results of the test today was responsible. And marijuana. And say he has a prescription. Site is. Very steps. So you have to give you the name of the medication. He gave me a name. That's medication. This second. You know that Mr. Kleiner, any questions? So, Mr. Wardell,
I do plan on sending off a confirmation. You all right with that? I can say that it has. I just request that and ask for the judicial notice of the file that my client was admonished about the following conditions.
any questions? Mr. Wardell?
No, you're on.
All right, thank you, Mr. Whitehill. All right, court's gonna find that Mr. Cooper, having signed the conditions of pretrial release, I have. This is they violating the conditions of pretrial release by taking positive for methamphetamine, marijuana, into the hazard. Or will grant the request by Mr. Weiner to send the sample off for further confirmation with the lab. Court at this time is going to find Mr. Cooper in violation of court's pretrial release conditions. Of course, going to find his bail to be insufficient. Of course, going to revoke that bail, place Mr. Cooper back in custody. Should our lab confirmation providing the issues that will consider the bill.
Any good reason available sign.
I'm gonna have to research to see what the bill was originally, but I'll make sure you.
Everyone, thank you. I actually, one other thing, just for purposes of record, I don't have personal knowledge of it, but I was told that my client had a stroke level high blood pressure before coming in the courthouse today, which I think could be impacting his parents' ability to communicate. And so I would just ask that you ask the sheriff's department to have his blood pressure checked when he is in their details, make sure that that will.
Yes, sir.
Thank you very much.
Rotates. And you guys stated, speaking like that. Speaking for something. Thank you. Mr. Booker, are you ready, sir? Go ahead and have a seat. This is cause number CR 22-239, State of Texas versus Jimmy Saul Booker. Mr. Booker, we were scheduled here today for a hearing on the state's motion to develop your community supervision. The court has previously found that you were competent to represent yourself pro se, you still wish to continue today in that capacity? Okay. And, Mr. Booker, it's, apparent to me based on the plea agreement paperwork that's been sent to me that you have reached an agreement with the state of Texas regarding your revocation and that you're asking the board to review that today and approve that. Is that correct? You met with, can you tell me who you met with? You met with Ms. Tommy Perry and you discussed your case, you discussed what her offer was. And you've reached an agreement. Can you tell me what that agreement is? All right. Mr. Booker, I find that you appeared before the court on February 23rd, 2023. You were convicted of the offense failed to comply with sex offender's duty to register by a second degree felony offense. Court finds that on that day you reached a plea agreement with the state of Texas. Your punishment was assessed that day pursuant to a plea agreement at 10 days or 10 years confinement in the Texas Department of Criminal Justice Institution Division and a $1,500 fine. Court followed your plea agreement, assessed that sentence, but then suspended it and placed you on 5 years of community supervision. It was during your period of community supervision that the state filed its amended motion to revoke your community supervision. And the state alleged in what appears to be 4 counts of ways that you have violated your community supervision. At this time, Mr. Booker, I would ask you, how do you plead to counts 1, 2, 3, and 4 as containing that motion? Those counts true or not true?
Count 2 and count 4. Count 1 is part of the agreement that you agreed to dismiss. And I think she mentioned that 42 is supposed to have probation. I think that was an error there. On the 3G. Well, I just agreed to go ahead and do the free bargain for the 9 years.
Okay, so you're pleading true to counts 1. I'm sorry, you're pleading true to counts 2, which is that on about April 7th, 2023, you admit to swallowing alcohol. Then count 4, you plead true that you failed to report them to the Benson County Community Supervision and Corrections Department. Right. For the month of March 2023.
Yes, sir.
And you're pleading not true, or as part of your agreement that counts 1 and 3 are going to be abandoned by the state. Is that correct?
Yes.
Mr. Hartwell, do you know if that's the case? Is that part of the agreement?
Your Honor, I do know that we were not going to press charge Mr. Booker with the possession. I don't know for sure if we were agreeing to abandon count 1. All I know is that we were not going to push the new charge. If the court will give me just a moment, I can confirm this. Thank you, Your Honor. Your Honor, in speaking with Ms. Spurry, we are not abandoning count one, but we are agreeing to not pursue a new case. But we are maintaining count one.
You understand though that Mr. Booker's plea not true to that count?
Yes, sir.
There's going to be some evidence before the court to prove count one.
Yes, Your Honor, and state does have Officer Bo Cook here and is able to present evidence today.
The plan today was to prove the motion.
If
And also play true to it.
if needed to prove it up, Your Honor.
It's very interesting. Can I have her in here?
I'll see if I can get her.
Ask her to step in so we can conclude this. So I can launch the jail.
Yes, Your Honor.
If it please, go it. I think I found it.
Let's wait until the state's attorneys get back in here so they can be part of this. It's okay, I know you're burning it both ends. We're in the plea process with Mr. Booker. And Mr. Butcher has indicated he has reached an agreement with your office. He's indicated that plea agreement consisted of a couple of things that the state would be dismissing the allegation of possession of controlled substance in 2031. I see that reflected in the judgment under section 12.5. However, when it comes down to counts 1 through 4, Mr. Booker indicated that we'd be completely true to counts 2 and 4, but not to 1 and 3. I think he was under the impression that the state was abandoning count 1 and 3, which was count 1 was knowingly possessed of a controlled substance, which I assume, I don't know, as part of the 12.5. And then condition 3 was a positive test for amphetamines.
Your Honor, I don't recall at all discussing number 3 with him, the positive drug test. With regard to number 1, I did agree to, and the court is right. Number 1, violation number 1 is the same as the charge that we bring against Mr. Booker. I did agree with him that he pled 3 years today and agreed to the state recommended sentence of 9 years. If we did not bring that other charge that we 1245 expensive. We did not specifically discuss whether he would be pleading true to it in this action, nor did we discuss whether he would plead true to it to number 3. I have recorded conversations between myself and Mr. Booker since he was representing himself. In order to protect myself, I recorded all of our conversations where he admitted to me. So I believe he admitted to me that he had smoked meth as he latched, but he had done some privacy from mother's home. So I believe those would be easy for us to prove. However, I don't want to or wrenching this over something that may not matter in the end. So if he is willing to persistently with us accepting and with us abandoning 1 and 3, state will proceed that way.
Booker.
I agree with the state.
So the court finds that the state is abandoning counts 1 and 3. And so, Mr. Booker, how do you plead to counts 2 and 4?
I'm pleading true.
Are you pleading true to counts 2 and 4 because those counts are true? You're not just saying that those are true, so you get a certain plea agreement. Is that correct?
Yes, Your Honor.
Has anyone threatened, forced, pressured you to plead true to counts 2 and 4 here today? No. Court will accept the defendant's plea of true counts 2 and 4. Mr. Booker, you looked over the paperwork, you signed this paperwork, that is your plea agreement. Is that correct?
Yes, Your Honor.
Like you've had enough time to read over that to the point you understand everything that you've read and signed.
Yes, Your Honor.
Do you have any questions about any of the paperwork and what it means?
Got no further questions.
Okay. And do you have any objections to the court admitting into evidence your waiver of rights to plea of true to the state's motion to revoke?
Yes.
Sorry. Court will admit that into evidence. The court takes judicial notice of Mr. Booker's judicial position. Is there anything further from the state?
No, Your Honor.
Mr. Booker's further that you would like to say on your behalf?
No, Your Honor, I'm just, just ready to put this in.
And just so that we're clear before I follow the plea agreement, let me read the plea agreement to you. Make sure you've read it. Let's make sure that we're all on the same page. You're asking this court today to find that you have violated your community supervision, to revoke that community supervision, to assess punishment of 9 years confinement in the Texas Department of Criminal Justice Institutional Division. Order you to pay the balance of your financial obligations, which includes fines, court costs, reimbursement fees, and the court to dismiss unfiled DA 2023-460, which is that possession of controlled substance one, and to give you 97 days credit towards your sentence for the time that you've already been in jail. Is that correct?
Yes, Your Honor.
Okay. All right, then based on the evidence before the court finds that the defendant today self-represented with the approval of the court, finds that Mr. Booker finds that he has engaged in negotiations with the state of Texas. The court finds that there exists a plea agreement between the state and in this case, the court finds that based on the evidence that Mr. Booker has violated the terms and conditions of his community supervision, the court will follow the plea agreement reached today between the state and defense. Or hereby, based on that finding, revokes Mr. Booker's community supervision, assesses his punishment at 9 years confinement. Texas Department of Criminal Justice orders him to pay the balance of his financial obligations, including a $1,500 fine, $245 court cost, and $90 reimbursement fees. Court dismisses under section 1245, clause 58 2023-460, a possession of controlled substance one less than 1 gram. The court awards Mr. Booker 97 days credit towards his sentence for the time that he has spent on this case. Right, Mr. Booker, you're hereby remanded into the custody of the sheriff, so he carry out the terms and conditions of his sentence. Deputy Martinez is going to come over there to you, so take your fingerprint, and then you'll take. Oh, I didn't look up. It's not Deputy Martinez. All right, Ms. Tableham, I'm ready for you at the jail.
All right, we're ready.
Who are you ready on first?
Miss Dobie.
All right, cause for CR 22-130, CR 22-131, State versus Shayna Sapien Dobie, or docket call. Go ahead, Mr. Prater.
Actually, it's Mr. Stevens, Your Honor.
Okay, Mr. Stevens. All right, go ahead, Mr. Stevens.
We've asked for a reset. We've gotten all the discovery, we believe. There's a few items that are missing a few pages, but I don't think it's a big deal. But we've discovered something that we need to get subpoenas issued on to obtain some additional records that probably wouldn't have been furnished to discovery. So I just asked for a reset.
We still need to give out a microphone. People don't hear anything. Mr. Stevens, can you you repeat what are the two items that you are referencing with the benefit of the state?
I'm sorry, I couldn't hear everything you said, John.
Can you repeat what are the two items that you are requesting from the state?
What are the two items that you're requesting from the state, Mr. Stevens?
As far as which are you talking about?
Well, correct me if I'm wrong, Mr. Stevens, you're asking for a reset because you said there's a couple of items that you're requesting in scope.
There's some records pertaining to police officer training and any expertise that they may have in certain fields that after we got the discovery on the last setting and we had an expert look at the videos, he suggested that there were some questions that we needed answered as far as some of the police officers training and experience and expertise in certain fields.
Okay, and is that for purposes of a pre-trial hearing issue, motion to suppress, motion to quash, or is that just for trial preparation?
For potential.
I'm sorry, we have really bad bandwidth, it says our bandwidth is very low, so I'm not able to hear you very well. Can you say that again?
Yes, Your Honor, it pertains to a potential motion, a few issues.
Motion to suppress a few issues. My only concern is I'm not sure how you have multiple settings. I think this is the first I've heard of this. Usually we don't set things for docket call. I don't set things for docket call until the attorneys have told me that they've received everything and there are no contested pretrial motions. So I'm a little surprised by this.
It was in a video that we had not had yet as far as until the last setting.
I'm having difficulty hearing exactly what he says that they are missing, Your Honor. However, I will say, and I don't know if it was this counsel with Mr. Fratter or if it was only Mr. Fratter, but I know at least Mr. Fratter came to our office with his computer, sat with one of our laptops that we took to our electronic file and went through line by line with Ms. Melton, one of our legal assistants, and made sure that he had everything that we have. So I'm not sure what it is that they think they could be missing.
Well, he's indicated he's asking for records regarding police officer training. So it sounds like he's wanting the CV of your police officers.
He has not filed such a motion, Judge. And our standing pretrial letter tells them that those are available at the agency. All they have to do is contact the head of the agency.
Did you hear that, Mr. Stevens?
Yes, Your Honor.
So am I safe to assume then that this case is going to be heading to trial and that there's no need to set this for a plea demo? Is that correct?
I'd like the court to set it for a plea deadline to perhaps give us some motivation to talk, Judge.
Well, my concern is today was that plea deadline.
Oh, okay.
Today is docket call, which is just why I'm confused as to why we're asking for motions to suppress and additional discovery. All of those things should have been done at our last pre-trial setting. We shouldn't have set it for a docket call today if we were not at a point where we were satisfied we had everything we needed. So today is the plea deadline. I don't mind setting it, out a couple of weeks, but I don't want to continue to set it for docket call, a plea deadline, and then hear, well, now we want to do this, now we want to do that. We need to get it either set for trial or set for plea. So, Mr. Stevens, how much time are you asking for?
3 more weeks. Max, I think we need.
And I'm sorry, I can't hear you. What'd you say?
I think 3 or 4 weeks was the plan.
3 or 4 weeks. Any objection from the state?
No, Your Honor.
All right, Mr. Stevens, I can set it for August 8th or August 10th.
August 10th would be better, Your Honor.
All right, court's gonna set a final docket call, so Mr. Stevens, whether it's you or Mr. Fratter or someone else, on August 10th. Unless there is some development in the case that is unbeknownst to the state or to the defense, I expect that on that date, all of the negotiations, all of the discovery, all the pretrial issues, all those things that have already been done. For y'all to tell me whether there's gonna be a plea agreement or there's not. If there's not, you want a bench trial or you want a jury trial. So August 10th is that deadline for all intents and purposes. Are we clear?
Yes, Your Honor.
All right, thank you, sir. Appreciate it.
Thank you.
Good afternoon, Your Honor. Mr. Schmidt should be with you momentarily.
Deputy, please, will you do me a favor?
Absolutely.
The bandwidth is so low, I don't know how to fix it. It's gonna make it very difficult for us to proceed this afternoon, manner that we're going. Would you do me a favor, would you disconnect, let's try the old IT trick of unplugging, plugging back in. And
Yes, sir.
dial back in and I'll, maybe that'll fix it, I don't know, but I think it's gonna get to the point where we're gonna spend a lot of time getting this.
Yes, sir. We'll even do a reboot as well. So we'll see you.
I'm sorry, thank you.